Hi everyone, I'm David. If you are a startup founder, entrepreneur, or global innovator thinking about living and working in the United States, today's video is for you. We're talking about the O-1 visa, the visa for individual with extraordinary ability. Now, when people hear extraordinary ability, they usually think, wait, is that for Nobel Prize winners? Do I need to be the next Elon Musk? Relax, you do not need to be a rocket scientist, but you do need to show how you've made your real impact in your field. Today, I'm going to break this down in simple ways. What O-1 visa actually is, who qualifies, how founders structure it, common mistakes, and why it might be better than H-1B for entrepreneurs. So let's get into it. So what exactly is O-1 visa? The O-1 visa is for individuals who have demonstrated extraordinary ability in science, business, technology, education, arts, and athletics. For most startup founders, we're talking about O-1A, extraordinary ability in science, business, or technology. The key phrase in the law is sustained national or international acclaim. Two important words, sustain and acclaim. This isn't about one lucky article or one viral post. It's about showing that over time, in your industry, recognize your work as significant. Unlike H-1B, there's no lottery, no annual cap, and you can apply any time of the year. And you can premium process it. That's why founders love it. So what does extraordinary actually mean? Here's the good news. You do not need a Nobel Prize. Most applicants qualify by meeting at least 3 out of 8 regulatory criteria, such as major awards, media coverage, published articles, serving as a judge about the works, really high salary, membership in exclusive associations, original contributions of major significance, critical role for distinguished organizations. For example, if you're an AI founder, your startup raised venture foundings and you've been featured in TechCrunch, have you spoken at industry conferences, in panels, and built patented technology, served as a startup competition judge, that can be a strong case. The focus is not do you feel extraordinary? The focus is does your industry recognize you as impactful? So how do founders structure an O-1? This is where it gets interesting. You cannot self-petition for an O-1. There must be a petitioner. And for founders, that usually means that your own company petitions for you, an agent structure, multi-employer arrangement. Depends on your situation. Here are the important part. You must show a legitimate employer-employee relationship. That means a real operating company, a board or oversight mechanisms that defines their job duties and separation of control. You can be the founder. You just can't be your own immigration supervisor. USCIS wants the Z structure, not a solo act. So why is O-1 so powerful for entrepreneurs? Let's compare briefly to H-1B. So here are some examples of H-1B challenges. Lottery system, limited cap, strict windows, and founders issues. O-1 advantages includes no lottery, no annual quota, faster processing, renewable, and indefinitely, and often easier to structure for founders. Many founders use O-1 as a bridge to EB-1A green card, EB-2 NIW, and other employment-based green card options down the road. It can be part of a long-term strategy. Here are some common misconceptions, so let's clear up a few myths. Myth number 1, I'm too young to get an O-1. Age doesn't matter, impact does. Myth number 2, I don't have a huge award or a degree. Most people don't, that's normal. Myth number 3, my company isn't public yet. No, you don't need to be at IPO level. C-stage founders can qualify if their credentials are strong. Myth number 4, I don't make a massive salary. High salary helps, but it's not mandatory. O-1 is about recognition and significance, not just income. So here's a reality check. Let's be honest, the O-1 is not something you throw together with 3 recommendation letters and hope for the best. USCIS has become more sophisticated. Your petition needs clear positioning of your field, strong documentation, consistent narrative, well-structured evidence, thoughtful legal arguments. It's not just a checklist. It's a story backed by proof and evidence. So who are you? What have you built? Why does it matter? What should the US allow you to continue doing it here? That's the core question. So who should seriously consider O1? Here's some example. If you're a tech founder, AI or biotech entrepreneur, deep tech engineer, venture-backed startup executive, recognized product or research leader, and you've raised capital, been featured in media and conferences, built patented technology, published research, led significant innovation in the field, you should absolutely evaluate O1. Here's the bottom line. O1 visa is not a genius visa. It's a visa for people who have already demonstrated value in their field. If you're building something meaningful and gaining recognitions, don't let the word extraordinary intimidate you. You might be more qualified than you think. So if you want to learn more about whether you qualify, feel free to email or text us and subscribe for more founder-focused immigration strategies content. I'll see you in the next video. Peace.